Today we are going to discuss something very important in relation to Article 129 and Article 215 of the Indian Constitution. Now Article 129, it says that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Here you will notice the expression shall have all the powers of such a court of record. It will always include such power, including the contempt power. So one thing is very clear, that power of contempt is always inherent in the court of record. So here the question arises that what is the meaning of court of record? So court of record simply means where the acts and the proceedings of the court records for perpetual period of time, and those acts and proceedings of the court, when they are produced in evidence, the validity of those acts and proceedings cannot be questioned by any court. That is called the court of record. In order to have the better understanding of the court of record, we need to go through the Supreme Court rules, part 7, order 46. When you read it, you will find destruction of record. And this record of the Supreme Court is divided in two parts, part 1 and part 2. So in part 1, you will find the record of the Supreme Court which is preserved for permanent period of time, and it includes judgment, index, decree or order, pleadings, plain written statement, and so on. And in part 2, the limited time period is given, and for limited period of time only that record will be preserved by the Supreme Court. And the example for that is appearance, power of attorney, wakalatnama, affidavit, taxation files, including the bill of cost. And the relevant judgment for this is SCBA versus Union of India 1998 Supreme Court. See you tomorrow.